Obviously, yesterday was a disappointment. But they've been disappointed before. The families knew and were well advised by ourselves that Soldier F was appearing in court charged with the murders and attempted murders. It was in relation to just a sliver of the evidence which once was available. Like, I mean, for example, many witnesses were no longer available. The families knew that. So the families were ready for the likelihood of acquittals. I think they hoped that there could have been a conviction on the seventh count, but even in relation to that, we had them ready, and braced for bad news. But that's not to say that the families weren't still entitled to have this matter pursued. Obviously, the Public Prosecution Service had their own tests. They received senior counsel's advice before mounting the prosecution. They applied the test for prosecution. And not only that, Soldier F's own legal team attempted on 2 occasions to have the prosecution thrown out, as it were, because the evidence was unreliable or inadmissible, and still the case went through to its ultimate conclusion. So they feel vindicated that they supported the prosecution, and a level of accountability had been achieved in relation to what happened.
And I want to ask you about what you think needs to happen regarding the issues of perjury, which was laid out by Judge Patrick Lynch, who said that I hold that witnesses have told lies about the events on several occasions, and he pointed to Soldier H, who he said had twice committed perjury when giving evidence to the Widgery Tribunal, and the Bloody Sunday inquiry conducted by Lord Saville, and Soldier G once when giving evidence to the Widgery. What can happen next?
We have made submissions about this before. The PPS decided on the 19th of April 2024, so that's almost 18 months ago, that they would not prosecute any paratrooper for perjury, and they looked at only the soldiers who opened fire. We immediately sent pre-action judicial review correspondence seeking to challenge that decision. Firstly, before any judicial review can take place, there is a review of that decision, which first must be gone through. That review has not happened, but we understood that process to conclude very, very shortly. With Judge Lynch's comments, particularly in relation to Soldier H, Soldier G, as you've noted, he died during the 1970s. So obviously, it's Soldier H that the focus centres in on. Judge Lynch actually also said that this witness was serially untruthful to matters central to the inquiries in the Bloody Sunday. This is something that the Public Prosecution Service need to take fully on board. The recordings of the evidence are there. The versions of the statements are there. The sworn evidence of the soldier in particular, it's all there. Everything is there, which really makes it absolutely incumbent, and there should not be further delay in reaching a direction in respect of a decision to prosecute Soldier H in particular for perjury.
When you use that phrase, without further delay, this is more than half a century later. Without further delay probably couldn't speak more loudly or speak louder to the families than that. Could you put a time frame on this? Is there a time frame you'd like to see? Any sort of resolution on a decision whether to or whether not to prosecute for perjury?
I see no reason why a direction could not issue in relation to perjury by the end of the month in relation to Soldier H. There's no excuse for it anymore. And the one point I would like to make to you is, and it's very important, this is not a witch hunt against soldiers. Soldier H would not be facing a prosecution for perjury, and Soldier F never would have had to go through a prosecution for murder and attempted murder if they only took the Attorney General's assurance in respect of self-incrimination that if they told the truth, they would not see a prosecution in relation to them.